Good morning, students. Today we are going to deal with a very old English case law, that is Carlill versus Carbolic Smoke Company. Okay, look at the citation. The case was decided in 1892. Very old indeed, no? Okay. Now, before I actually explain this case law, I want to tell you that this is one among the case laws which is very close to my heart, because this was the first case law I have studied as a law student. Okay, not only me myself, many law students study this case law as their first case law in their law school. Okay, so that shows this is one of the pillars of English common law. Okay. Now, Carlill versus Carbolic Smoke Company. What are the facts of the case and what is the judgment? I'll explain to you. Before that, I want to show you a very old advertisement. Okay, ready? Yeah. Look at this advertisement. This has appeared in London News in 1891 November. This is an image which I have taken from internet and I have given credit down. Okay, who is the original uploader? Okay, now since it is an old paper, things are not very clear, I know, but you can see what is written: Carbolic Smoke Ball. Is it not clear? Yes. Then you can see £100 reward. That is very clear. Down that you will be able to read influenza, which is written in capital letters. Again down, see, there is £1,000 is deposited. Is it not? It is still clear. Yes. Now what you can see is the Carbolic Smoke Ball. This much all of you can see. Okay. Now if I show you like this, there is something more written. Carbolic Smoke Ball will positively cure. Okay, yeah. Now many other things are written in the advertisement. Since it is being very old, things are not very clear. That's okay. Okay, now I will explain you, and you can see two ladies who are using this smoke ball also. Okay, now what are the facts of the case? What happened? Actually 1889 to 1890. The world was affected by flu pandemic. See, right now we are managing the ongoing crisis of COVID-19. Is it not? So we all are looking different ways on how to combat with this disease, how to overcome. All methods are being tested. So the same thing has happened that time. If you actually Google, you can see the images of that time, pandemic times, where the images are more or less the same, like people are wearing masks, people are keeping social distance, like how we are doing right now. Okay, so this I also want to tell you that the pandemic situation is not something new. It has happened before and people have survived. The world has triumphed over such diseases. So we should also keep it in mind that we can also survive and we will actually come out much stronger and disciplined community. Okay, do not worry about it. Right now we need to take precautions and stay healthy. Okay, so this flu pandemic is estimated to have killed 1 million people at that time. Remember, at that time. Okay. Now, what about our case law? During this time, this advertisement came about Carbolic Smoke Ball. Okay. Now, this is a rubber ball. It's not a medicine. It's a rubber ball. A ball and a tube is attached to it. And it is filled with carbolic acid. Okay. Now, the tube would be inserted into the user's nose and squeezed at the bottom to release the vapor. It is kind of inhaler. So, what did they advertise? That you use this, see, we have seen the advertisement, use this Carbolic Smoke Ball. There is a prescription also. What is the prescription says? 3 times daily for 2 weeks. Okay. And they also ensured that, as I told you, they said it will positively cure. Not only that, in the advertisement they said, if you are using this as per our instruction, flu will never come near you. That means you are totally free from this pandemic. You will not have any problems, and you have to just use this as per our instruction. Okay. Now, why are they giving this 100 pounds reward? Because they said that we are challenging you. No one will be having this flu if you have used this. And if at all anyone fell sick, in spite of using our medicine, we are giving 100 pounds reward. Okay. Not only that, in order to give that 100 pounds reward, 1000 pounds is deposited in a bank. That is what the advertisement stated. So that shows that the company is so serious about their claim that if you are using this smoke ball, there won't be any problem at all. Okay. Now, Mrs. Carlill saw this advertisement, and like now, the psychology of people was the same. Like everybody was waiting for a magical cure, and people were ready to buy also. Okay. So Mrs. Carlill was one among them, and she purchased this medicine. Medicine means this carbolic smoke ball, and she used it as per the instructions till she fell sick. Okay. This is the interesting part of the story. So naturally, she was taken to hospital. She was given good treatment, and thankfully, she was recovered from her disease. Okay. But she is not the kind who was ready to leave. After she came back from the hospital, she immediately wrote to the company asking for this 100 pounds reward. Okay. Company did not reply. Twice she sent a letter. Company did not reply. She sent another letter, the third letter, through her solicitor to show that she is very serious about it. Still, the company didn't reply. That means company has no plan to give the money, or they were not very serious about it. It was just, they just wanted to create an impression in the people that we are very serious. But they were not ready to pay the money. So, Mrs. Carlill, naturally, she was very angry, and she approached the court. Okay, now let us see what happened. Before the court, both Mrs. Carlill and the smoke ball company made their own arguments naturally. Now let us see what is claim of Mrs. Carlill. Mrs. Carlill said, you have made a general offer through an advertisement. Okay. I have accepted it by buying the medicine, using it according to your instructions. And therefore, the company is bound to pay the reward. Since they did not pay the reward, now they have to pay compensation also. Okay. Now to this, what did the smoke ball company said? The company said it was just a puff. It was just an advertisement. What is a puff? You have something and you are puffing it up. Too much of exaggeration. See, nowadays also we see such advertisements, like there will be an advertisement of a shampoo which will tell you that using this shampoo your hair will become stronger enough to pull a truck by using the hair. Have you not seen such advertisements? Yes. So now such puff is allowed. That time also puff was allowed. Okay. So they said this is just a puff. We are actually making an advertisement, and there is no general offer we made. We were actually making an invitation to an offer. Here, my students, I want to explain it to you. What is the difference between an invitation to an offer and a general offer? A general offer is one where the one who makes the offer is very clear about what he wants to do. He or she wants to do. He is expressing his desire to do or not to do something, and when he is making it, he has an intention to create a legal relation. He wants the other party to agree to it and therefore make it into a valid contract. Whereas an invitation to an offer is just an invitation. Say for example, you are passing through and you are seeing a shop, and the shops normally do a window shopping, window dressing, window display you can say. Say for example, a garment shop. A shop will exhibit trendy and exquisite or beautiful attires in the window, and most often along with the price. Have you not seen? Yes. So that means they are trying to catch your attention, and therefore they are trying to induce you inside the shop so that you will do actual shopping. Okay, so when you go to the shop, you will see the material, then you will actually make an offer which may or may not be accepted by the shop owner. Similarly, a menu card in the restaurant. You cannot insist that whatever is written in the menu card should be available. It is an invitation to an offer. After reading the menu card, you can make an offer. There are many invitations to offer like this. Say for example, a catalog, a price list. All these are invitation to an offer. So after getting this invitation, now you are making an offer which may or may not be accepted. Okay, and therefore an invitation to an offer will not make any valid contract. Okay, so the company said we were just making an invitation to an offer, we have not made an offer, and therefore there is no acceptance, no legal relation, and therefore there is no valid contract. Okay, now I want you to see what the judges said at that time. Okay. See, Carlill versus Carbolic Smoke Company is a beautiful example of how judges develop law. Even though we say it is the legislature which makes law, large part of both English law and Indian law is developed by insightful judges. This is one example of that. Okay, what the judge said. See, if it was only an advertisement of this Carbolic Smoke ball, no doubt it is an advertisement and therefore it is an invitation to an offer. But here, the company has made a claim that we have deposited £1,000 in the bank and we are ready to give £100 if you are meeting the condition. What is the condition? You should use it according to our instructions, and not only that, you should fall sick. Okay, so by making this kind of a claim, the company has advanced one stage, that from an advertisement it has actually gone to the stage of making a general offer to the public, and a general offer is one which can be accepted from anyone in the public by meeting the conditions. So here Mrs. Carlill, by buying the medicine and using it as per the instruction, has accepted through her actions. So the offer is accepted. Now comes consideration. Actually, interestingly, the judges said twice she has paid the consideration. One, the amount of money which she paid for buying the medicine. Second one, she has suffered the inconvenience of using this medicine without any use. So enough consideration is there, and both Smoke Ball Company and Mrs. Carlill had an intention to create it into a legal relationship, and therefore all the important essentials of a valid contract is met in this case, and therefore there is a contract and the company is bound to pay. Okay. So in conclusion, this was observed that an offer intended to be acted upon, when acted upon and the conditions performed, constitute an agreement.